A Florida pastor is accused of sexually assaulting two underage girls on church grounds. Authorities say he told one of the victims, "We only live once." Yersson Solarte faces charges of sexual battery of a minor and lewd and lascivious molestation. If convicted, he could spend decades in prison. I'm Kennedi Walker, and I'll walk you through the allegations, the evidence, and what could put the pastor away for years. Nearly every Sunday, Florida pastor Yersson Solarte stood behind the pulpit at E-Pool Pentecostal Church, preaching to his congregation, sometimes with tears in his eyes. But today, the pastor isn't weeping in worship. He's wearing an orange jail jumpsuit. Solarte has been arrested and charged with sexually assaulting two underage girls. Police say the first reports of an alleged inappropriate relationship surfaced on April 10th. According to a statement from the Sanford Police Department, Solarte inappropriately touched both victims and sexually assaulted one of them. Prosecutors say the alleged assaults happened inside E-Pool Pentecostal Church, the very place Solarte delivered his sermons. According to an arrest affidavit obtained by the Miami Herald, one victim told authorities that Solarte repeatedly made her sit on his lap, allegedly sexually assaulting her in his office and the church's multimedia room. Investigators say they later uncovered allegations from a second girl claiming the pastor had abused her several times. According to court documents, the girl told authorities that Solarte expressed his love for her before hugging her sister in what she believed was an attempt to make her jealous. The affidavit further alleges Solarte forcefully grabbed the girl's face to kiss her and molested her twice, telling her, "We only live once." Investigators say at one point he allegedly unzipped his pants and told the girl they were now a couple. Then the girl asked him to call her mom. Both minors were members of the church. Officials confirm Solarte has since been removed from his position as pastor. Authorities arrested him while he was vacationing with family in Virginia. He is now charged with sexual battery of a minor and lewd and lascivious molestation. In a statement, Sanford Police Chief Cecil Smith said, "People like this are a special class of criminal who use their position of trust to prey on innocent victims. Solarte is now behind bars where he belongs." And joining me to talk more about this is former child abuse and sex crimes prosecutor Marian Bracha. Marian, thank you so much for coming on today. Let's get right to it. What exactly do the charges of sexual battery of a minor and lewd and lascivious molestation mean under Florida law?
So that basically means that there was physical contact between an adult, between someone over the age of 18 and someone under the age of 16, or at an age difference of greater than 4 years from the alleged perpetrator. It means also that the contact that was alleged to have occurred between the parties occurred between the intimate parts. Ordinarily, that means the genital area. It doesn't always mean the genital area, but typically the intimate parts of the parties. And certainly it means that that contact was effected with the intent to arouse or satisfy sexual desire. So it wasn't a good faith medical basis. It wasn't for hygiene. It wasn't for a medical examination or anything accidental. So there is an intentionality element to it that needs to be proven by the prosecutors as well.
What potential sentences could Solarte face if he's convicted?
There are any number of options available for the judge who would impose a sentence if there was, in fact, a conviction in this case. Certainly, prison or jail time would be an option for a certain number of years. But with charges like this, the more lasting ramifications are really the Megan's Law registration requirements that typically accompany these sexual offenses that would require a convicted person to register as a sex offender either for a lifetime or for a period of years, again, depending on the statute under which he was convicted. And that really does have lasting social, professional, personal consequences on someone who is on that list.
How does the law treat sexual crimes that happen on religious property? Does that change anything at all?
I don't think there is any separate statutory definition for sexual offenses or any other crime that would occur on the grounds of a house of worship or anything of the like. I think that the circumstances are certainly taken into consideration by a fact finder and certainly by a judge if it got to a sentencing phase. The fact that this is supposedly sacred territory, this is something that is intended to be a very special or hallowed area, and the fact that it is abused and disrespected. Again, if that is proven, that would be something I think that would be taken into consideration by a fact finder. But there isn't, so far as I know, any kind of sentencing enhancement or upgrade because of the location of the alleged acts.
Gotcha. Well, what about prosecutors claim that there are two victims. Does the fact that there are multiple victims increase the potential punishment?
It could, certainly, because they would be charged under two separate criminal complaints. The sentences would not merge, which means that they would not necessarily run concurrently. So there could be consecutive sentences opposed. Again, if there is a conviction on each complaint, meaning a conviction for the charges against each alleged victim, that could mean that a sentence would run or a sentence be imposed for the crimes perpetrated against one victim, and then consequent to that, or I should say subsequent to that, a sentence for the second victim could run consecutive to those charges. So we could potentially be talking about a lengthy term of punishment.
So are you saying that both victims' cases will not be tried together, or would they be separate trials? Is that what you're saying?
No, not necessarily. So I think a decision to try both charges together, both complaints together, is something that the prosecutors are intending to do. I think it in their strategy, it would probably go to show that, or their theory would be that this defendant, this charged person, violated or abused his authority and his position and the position of respect that he enjoyed within the church, the position of trust that he enjoyed within this particular community. And so the prosecutors, I think, would certainly seek to keep both of these victims' cases together and try the facts together. I could anticipate a world where the defense would want to sever the charges, which means that they would separate and make a motion before the judge to try each case separately so that the fact finder or the jury would not hear testimony from two victims within the same proceeding. I think the defense theory would be, or the defense concern would be, that very similar testimony from two separate victims might add weight and credibility to each of their accounts. And so to give the defendant as much of an opportunity at fairness or objectivity, they would seek to separate the testimony of these two victims. That would be a decision that the judge would render before the trial commences.
Is it common for cases like this to also involve federal charges, or will this likely stay a state case?
Well, I think the only the only area that I would see for the eligibility for a federal charge would be if any of these activities entailed crossing state lines, because as you and your viewers know, the federal authorities would have that charging authority if there was anything that affected what we call interstate commerce. And so there would have to be a showing that perhaps the victims were taken across state lines, or that some other aspect of interstate commerce was triggered or affected by this particular defendant's alleged activities. So far, with what we know about the case, I'm not seeing anything that would trigger a federal charge. So it is highly likely that this would stay in state court as a state prosecution.
Gotcha. Yeah, and we know that the suspect, he was arrested in another state, arrested in Virginia, but that wouldn't have anything to do with this, right?
Not necessarily. There might be some argument, again, by the prosecution to introduce that evidence, the fact that he left the jurisdiction and had to be extradited or taken from Virginia back to Florida to be prosecuted. That's that would be entered perhaps and introduced at trial as evidence of what we call consciousness of guilt. Perhaps the defendant was trying to get away or trying to get out of Dodge, so to speak, and so that flight or that evasion from Florida authorities might be used as an indication that the defendant knew what he had done was wrong. That would be an argument that the prosecutors would make, but merely leaving the jurisdiction and requiring an extradition would not trigger a federal charge in this case, as far as I know.
Gotcha. And so let's move on to the alleged victims. How important is victim testimony in a case like this? Can the case proceed if, let's say, one victim refuses to testify? How would that work?
So victim testimony, especially in cases where there is no physical evidence, is incredibly important. And when we talk about physical evidence, we're talking about physical injury. We're talking about some indicia of assault or battery, evidence of medical treatment that was required after the particular physical activity or sexual activity between the parties. And so in the absence of that, if there is no physical evidence to present to the fact finder, then really, what the jury, what the fact finder is left with is the word of these two complaining witnesses, the alleged victims, and their testimony, if believed by the jury, would be enough in and of itself to convict any defendant beyond a reasonable doubt. So their testimony is of utmost importance. Their testimony and the believability of their testimony and their believability as live witnesses in this case are of utmost importance. Could the case proceed without their testimony? Maybe, under a very creative prosecution theory, under a very creative use of the rules of evidence. Again, it would really depend on what other evidence exists in the form of statements made to loved ones, to family members, what we call prompt complaint. Perhaps there were statements made in medical records. Perhaps there are other kind of circumstantial pieces of evidence that would go to support the claims. But really, in a case like this, the testimony is the star witness, so to speak.
And how do, prosecutors make sure that the victims, like, their identity doesn't get out or that they aren't re-traumatized or re-victimized? How do they make sure? Because, testifying can be a very scary process. So for those that, those victims, if they are scared of seeing him again or testifying in open court, how do they just make sure that they are protected?
Well, I think you're right that is always a concern. That's always a concern of prosecutors, and should, I hope, it be a concern of the court and court staff. As you, of course, know as well, there is a Sixth Amendment right to confrontation, which means that any defendant in this country who is charged with a crime has a right to confront his accuser, which means be face to face and hear the testimony live. There are very, very, I would say, limited circumstances under which especially minors or children can testify in camera proceedings, which means that they are closed proceedings and they just would have the judge and the attorneys present, perhaps the court reporter certainly to take down the testimony of the parties. But again, that would be under very limited circumstances and upon a motion by the prosecution. So I think that prosecutors do a lot of things to familiarize their witnesses with the whole court proceeding. They can show the witnesses the courtroom ahead of time. They can have them take the stand and again, familiarize themselves with the geography of the courtroom. But ultimately, this is a constitutional proceeding. This is one where the Constitution will trump essentially all other concerns in a courtroom. And if the prosecution does proceed with these charges, that will mean preparing the victims to testify in open court and to really have to work through the anxieties that they may have about testifying and speaking publicly and openly, even in the presence of the person who allegedly abused them.
And prosecutors, and police, according to reports, they're alleging that the pastor reportedly said, quote, "We only live once." How significant is the pastor's reported statement to the victim that we only live once in this case against him?
So that statement would be incredibly important. It would be introduced into evidence vis-a-vis the testimony of the alleged victims in this case. The statement of the defendant would be admissible as an exception to hearsay. It would be admissible by the prosecutors, and really it's something that prosecutors would ask the fact finder whether it has the ring of truth. Does it sound like something that the defendant would have said? Does it sound like something that is credibly relayed by the victim or victims in this case? And so ultimately, if that is the explanation or the statement that is being proffered by the prosecution as belonging to the defendant, then of course they would seek to admit that. And then again, whether or not the jury or the fact finder believes that the defendant said those statements and wants to give weight to them, that is entirely within the purview of the fact finder.
Could the church itself face legal consequences or lawsuits because the alleged assaults happened on their property?
Potentially, they could, yes. I think there would be a much harder, a much steeper climb, so to speak, a much higher burden to prove that criminal charges should attach to the church. But I think that civilly, if the victims or their families sought to file a cause of action against this, again, alleged perpetrator, civilly, they could also attach a cause of action to the church. There would have to be an argument of what we call respondeat superior, which means that the church was responsible for the actions of its agents or employees who were acting within the scope of their employment. Of course, in this hypothetical world where we're talking about a lawsuit that hasn't even been filed yet, I could imagine the church saying, well, we can't be responsible for the intentional criminal acts of an agent or employee who was clearly not acting within the scope of their employment or the scope of their duties that they owed to the church. So there would be some pretrial legal arguments that would be brought to hopefully to hash out whether or not that's a viable cause of action in the civil courts.
But could that argument be thrown out the window if it did, like the reports are saying, if it did allegedly happen at the church?
So again, the location isn't ultimately what is dispositive here, right? The fact that something or a crime or an abusive incident or incidents allegedly happened on the grounds of a church, again, the church's argument would be that that is something that was intentionally undertaken by a single actor, by this person who was not acting with the authority of the church. So there is an argument there on the part of the church, if they sought to bring that argument, that would say, this person was acting of their own accord, of their own volition. This was not within the scope of their employment or within the description of their duties. So if this was an intentional act, what we call an intentional tort, and not a crime not an act of negligence or something that would again come under the scope of our oversight of this employee, that the church, we cannot be responsible for it. But again, those are arguments that would be made or could be made somewhere down the line if a civil action were envisioned in this case.
Right, and that's for, a potential civil lawsuit. But criminally, if other church leaders knew about suspicious behavior and let's just say didn't report it, could they be charged?
So I think that's a question for someone who's more of an expert on Florida jurisprudence than I am. So there are requirements, certain reporting requirements for what we call mandatory reporters, people like teachers, people like certainly police officers, certain medical staff and personnel, and certainly church employees or church representatives or representatives of religious institutions as well. So we'd have to look at the mandatory reporting requirements of Florida to see who again, who within the church or who under the scope of this church employment, if they did have knowledge of this abusive behavior, what their reporting requirements were, and what penalties, if any, would attach if those reporting requirements were violated.
Gotcha. Well, what about, a plea deal? Are there plea deals in cases like this, and why might prosecutors or the defense consider one?
Sure. So I think there's always a possibility of a non-trial disposition, meaning that if a defendant chose to accept responsibility or it was in his best interest to not proceed to a trial and accept a guilty plea, or what we call a nolo contendere plea, meaning a no contest plea, that would certainly be available to the defendant. That would be a conversation that the defense team would have with the prosecutors if the prosecutors wanted to extend an offer, meaning that perhaps they dropped the lead charge, or perhaps there was some negotiation on the gradation of the charges. Then certainly those would be negotiations and conversations that were had between the attorneys in the case. I think if the prosecutors wanted to extend that offer, I think ultimately the interest is or the question is, would a non-trial disposition in this case or any other be in the interest of justice? Meaning, would it still be a fair sentence? Would it still be a legally sound charge on which or to which the defendant were to plead guilty or to plead nolo contendere? Is it within the best interest of the community and the victims to be spared having to testify in open court? And so these are, I think, all of the questions that go into a prosecutor's thinking and their consideration of whether or not to extend an offer for either a guilty plea or some other non-trial disposition. And I think the defendant would have just as meaningful conversations, or should have just as meaningful conversations with his attorney about whether it's in his best interest to avoid a trial, to proceed with a guilty plea or some kind of non-trial disposition, or to exercise his absolute constitutional right and hold the prosecution to their burden to prove each element of each crime charged beyond a reasonable doubt.
Great. And, I just have to ask before I let you go, any idea, what kind of defense might Solarte's attorney attempt in this case if they don't go the plea deal route?
I think a defense would be that there's insufficient evidence, that all of the prosecution evidence comes down to the testimony of these witnesses, the testimony that is uncorroborated by physical evidence or by forensic evidence, and that testimony or the word of one citizen, one witness against another party is insufficient to sustain the government's burden. So I think ultimately, if this is what we call a credibility case, and it comes down to purely the testimony of prosecution witnesses against the defense, that would ultimately be, or very likely be, the defense theory that there is just insufficient evidence to sustain the Commonwealth's burden, or sustain the government's burden. I'm in Pennsylvania, so I call it a Commonwealth.
Oh, yeah, no, I realize. Well, thank you so much for coming on today. This is a case that we will be following closely. Marion, thank you so much.
Thanks for having me.
Investigators believe there may be other victims and are asking anyone with information to come forward. For Law and Crime, I'm Kennedi Walker.